This is Gail Lee, and I'm the president of the board of Aging Advantage. We're a nonprofit here in the St. Louis area, which ensures quality service to families of the elderly and disabled individuals, helping you to manage your aspects of daily life while preserving dignity and independence. We do these caregiver training series, and they're partially funded and supported through the St. Louis Area Agency on Aging. And we're really happy for their support, and it just allows us to help the people in the area. And we give these classes online so more people can, take advantage of them. And today we have a most wonderful guest that's going to help us out and teach us some valuable skills as we're going into the holidays. This kind of comes up. People are coming home, they're visiting families, all kinds of things are happening. It's so important to have your affairs in order. But Amanda Wilson is an associate attorney here at Gantner in Capriano, an estate planning and elder law firm. And she's a little bit newer here, and she's just a great attorney and a great person to lead us off into our holiday season. So go ahead, Amanda.
All right. Hello, everybody. It's wonderful to be here. Thanks to Gail and Lee for having me. And today I'm going to talk about 5 really important legal documents everybody should have. Even if you don't have maybe a will or a trust, we'll talk a little bit about those later, but today I'm really going to focus on just the must-have legal documents and why they're so important. So before I go into that, I'll talk a little bit about the firm I work at, Gantner and Capriano. We do estate planning and elder law, a few related matters like trust administration and estate administration. We are members of the National Academy of Elder Law Attorneys and the American Academy of Estate Planning Attorneys. And we are accredited by the VA to handle veterans claims, which really a lot of firms are not. And that's super interesting. Gail knows a ton about applying for and acquiring VA benefits. I look forward to learning more about that as I get a little more experience, but this is a little bit about me. Like I said, my name's Amanda Wilson. I got a BA in economics and a BA in English from the University of Mississippi, which I loved. And then I went to Wake Forest University in North Carolina to get my JD. I just graduated this past May, passed the bar in September, and so now I'm learning a lot at Gantner and Capriano and with people like Gail who have taught me so much, and I'm really grateful for their support. So this is our elder law team at Gantner and Capriano. We do a lot in relation to Medicaid planning, veterans planning, stuff like that, and how estate planning works into the elder law side. This is our mission at Gantner and Capriano. We want to help families secure their legacies by embracing clients as members of our law firm family through long-term personal advisory relationships. And what that means is just we want to be there for you and your family as you go through life, as things come up, as people age. And we want it to feel like we are family to you, that you can come to us in times of emergency. Should anything come up, we want to be here for you. So your options as they relate to estate planning, you have 3. The first is not to plan at all. And it's not a great option. You can have no legal documents, and the only thing that means really is that you have no control. You have no control over your legacy or your estate once you pass away, and you lose control during life. And we'll talk about that when we talk about powers of attorney, but you have no ability to appoint anyone else to take care of your affairs unless you have these legal documents in place. So if something should happen to you, if you got in a car accident or something like that, you have no one that could make medical decisions for you. You have no one that could sign your name for you for financial reasons, unless you have powers of attorney in place. And that's super important. It's not something nice to think about. It's not something necessarily that people are anxious to get started, but it's something that's really important, especially for younger people as well, because after the age of 18, once you reach the age of majority, your parents can no longer make those decisions for you. And I know it's something that I hadn't considered. It's something that none of my friends had considered, right as we went to college, that, hey, if something happened to me, nobody could make those decisions and nobody could act on my behalf. Your second option is traditional planning, and this is a good option. This would give you a lot of the important documents that you would need, like powers of attorney. But legacy wealth planning is really the way to go, and that sort of folds in financial planning with estate planning. It's more of a comprehensive look of what are your goals today, what are your goals in the future, as far as finances go, as far as, family dynamics go. It's an ongoing relationship, and it provides you the most control over, what your assets look like, what your financial state looks like now, and what you want that to look like in the future as you age, and then after you pass away, what you want to leave to your children and how you want to leave that. Like many things in life, timing is everything. Planning is much better than not having a plan at all. And once you hit that state of emergency, almost always it's too late to plan. So it's really important to do this stuff now, when everyone is healthy, when you're healthy, when the people you love are healthy. So you have a plan in place in case these emergencies happen. So now I'm going to talk about the 5 documents for absolutely everyone. This is essential, what we consider to be essential estate planning. Every single person should have it, and every single person benefits from it. Every day in America, an average of 8,330 people die. And of these, a whole lot of them had not anticipated something happening to them. And sure, a lot of people, come down with an illness, something like that. They have time to plan, but a lot of people don't have time when something happens to make plans like these. And so that's why it's important to have these documents in place now versus later. Because of poor estate planning, the courts are also dealing with countless lawsuits over wills and poorly drafted trusts. I can't tell you how much in law school we talked about, LegalZoom and other, new websites, AI, stuff like that, that claims, you can draft a trust for free. You can have powers of attorney from the internet in 10 minutes for free. And isn't that great? But it's not, because a lot of times these documents don't do what you actually want them or need them to do. And you get what you pay for a lot of times. And unfortunately, that means if you're getting these documents off the internet, they're not the documents you want or need at all. And
Amanda, I have just a comment about that. It's interesting when I've worked here that, people will come in, and I've had these documents before because that's what they did. And then they're experiencing so many problems, and it's like you are getting what you paid for. Like those documents and that internet site didn't pay all that for law school, and maybe they are drafted in a way by lawyers, but the person that's inputting the data and deciding what to get is you, me, or whatever. And I didn't go to law school, so we don't know. Those people don't really know, and you pick stuff that's really not helpful, and so it can cost you even a lot more in the long run by trying a cheap thing.
I mean, even me and you, Gail, have seen clients come in here when they or their spouse needs to get on Medicaid, and they can no longer sign their names for themselves, and their spouse or their children think, oh, they had this power of attorney, we got it off the internet, it'll do everything we need it to do in order to, move assets around and make new accounts and all the things you have to do to apply for Medicaid. And it's not true. The powers of attorney don't do what they think that they'll do. And so it's really a dangerous thing, because so many people are fooled into thinking, oh, I'm protected now, and they're not.
It's exactly right. And I've seen it over and over.
Yeah.
That's why this is such an important talk.
And it makes it so hard for us then, because we aren't able to do a lot of the things we want and need to do for the elderly population to get people benefits. and to protect the assets that they worked their whole lives to have and to keep and to pass on to their loved ones.
And like you said, your friends, when you first went to law school or even college, you're just young and you don't think that you need it, but anybody really over the age of 18 needs it. And Lee, who's my daughter, like when she was just turning 18, she was talking and she was going to get those because was already aware that it was important and it was the holiday time, and so she was just kind of waiting for the holidays to be over, and she did get sick and she was having all kinds of problems at school, and then to try to leave school they'd have to call me for permission. But then when I took her to the doctor and she was really sick and I had to call to follow up, the urgent care was like, oh, she's 18, we can't talk to you. And she got on the phone. She's like, please, doctor. So she had those documents really, really, really fast, even when she was still in high school. So it's important.
And it's super important. And yeah, like I said, it's almost no one realizes how necessary it is. And once you're at the point where you do realize it, it's a lot of times it's too late. So what documents should you have in place? I know I've thrown around a few names of documents, but now I'm going to go through each of the 5 documents I want to talk about and why they're so important. So the first one is a property power of attorney. This is a general financial power of attorney. It's who could sign your name for you for financial reasons during your life if you should need some help. So let's say you go out tomorrow and you get into a car accident and your Discover bill and your electric bill are due on the 22nd of December. But you're in the hospital, you've got all kinds of medical problems. You can't pay these bills. If you have a property power of attorney in place, you could tell, okay, let's say it's your mom or your sister. You could tell them, hey, can you pay this bill for me? Which is super beneficial. And then as we go along in the elder law side, these powers of attorney are extremely important as it relates to Medicaid planning, Medicaid application, because a lot of times when people are looking to get on Medicaid or they're looking for their spouse to get on Medicaid, they might be dealing with something like Alzheimer's or dementia. So that individual is no longer competent to sign their own name. If they're not competent and without a property power of attorney, no one else can sign their name for them. So we can't do the planning that we need to do in order to get them eligible and on Medicaid. So property power of attorney, super important. And they're not all the same, which is what we had talked about before with LegalZoom and all of that. But there are traditional powers of attorney. Those can be very helpful, but really what you want is a Medicaid compliant power of attorney with gifting provisions. And that's important because it allows you to move money around for your loved one. And if there isn't a good power of attorney in place, then you're looking at guardianship. And guardianship is not ideal for anyone involved. It requires court supervision. It takes a very long time. It's significantly more expensive than paying to get a really strong power of attorney in place. So that's a financial power of attorney. I know ours in our office, it's about 40 pages long. Some people think that's ridiculous. It's not. We want you to be covered for whatever circumstance you need. So I know we have something in ours that relates to the selling of farm property. Well, it might not apply to you now, might not ever apply to you, but it might. And if it does, it's important to have these provisions in place so that we can do what we need to do when it needs to be done. So it's just important to think about, okay, how thorough are the documents I have? Are they going to cover me in case I need Medicaid? Are they going to allow me to sell assets or gift assets or change the form of an asset? And that's why it's important to talk to a professional about, these are the documents I have. Are they good? Are they not good? Are they going to do the things that are important to me and important to my family? So these are just things to think about. The next document I want to talk about is a healthcare power of attorney. It's a little different from a property or financial power of attorney. It's who can make medical decisions for you during your life if you were unable to make them for yourself. So you will make your own medical decisions until the point where you are no longer able to. And if you are no longer able to, you need to have someone who is able to make those decisions for you. By law, medical professionals are required to keep you alive so long as they can. And in law school, we read two cases. There were two women. One was in Texas and the other was in Florida, I think. Both of these women were young, I think 30s. And they had both gotten into car accidents that had rendered them in a permanent vegetative state. And in both cases, different family members, or in one, it was the husband and the parents, end up fighting about what to do. And the court said in both cases that these family members really had no right to do anything because neither of these women had powers of attorney in place. So it's great for a husband to say, that's my wife. She wouldn't want to, live like this. Or for the parents to say, no, she's our daughter. She would want to be kept alive. She would, she'll come back. But at the end of the day, none of that matters if you haven't actually designated a person to make medical decisions for you in a time of crisis. And then, healthcare powers of attorney can do other ancillary things, like they can get an autopsy if they wanted to know what happened to you, or they can move your body and plan your funeral. You can also make a designation on a healthcare power of attorney of whether you would want to donate your organs, which is a wonderful thing. So just some things to think about and super important in the medical context. Along with a healthcare power of attorney is a HIPAA authorization. And this is just what allows hospitals, doctors, nurses, all of those people to talk to your loved ones and give them medical information about you if you're unable to consent to that. So if you get in a car accident, you're unconscious without a HIPAA authorization, the doctors can't just speak to, whoever you might want them to speak to about your condition without you authorizing that. And so that's a really important document, and it's not a hard one, but super important. The next healthcare document that's also very important and kind of goes with healthcare power of attorney and what I was talking about before is advance directives and a living will. So your living will dictate, okay, let's say you're in that state. So you're in a permanent state of unconsciousness, or if you were at the end stages of a terminal disease, there is no chance you will regain consciousness. There's no real hope for any meaningful recovery. And at that point, you're being kept artificially alive. Do you want to be kept artificially alive? And some people do, and that's perfectly fine. And that's why this document is so important, because you can express your wishes in that situation. Yes, keep me alive. Maybe I will get better. Or if I'm living in a situation like that, just let me go. And that's okay too. So really, it's just about being able to express your wishes when you are no longer able to communicate them for yourself. And the advance directive just goes one step further from the living will. It says, if I'm in that situation, I would want, artificial nutrition and artificial hydration, pardon me. But I might not want something like CPR or dialysis, something like that. And so you can make these kinds of decisions ahead of time and really think about it, before you have these documents drafted of what do I want and in what circumstance do I want to remain alive when I'm in that position. And so that's why all of the healthcare documents are super important. So failing to plan is planning to fail. And this is kind of what we've been circling around this whole talk is, if you don't make a plan, then you're planning to fail. You're planning to leave your loved ones in a situation that they don't want to be in. They don't want to be making decisions or not being able to make decisions that you would want made, that they know you would want made, because they're not able to make them because you don't have these documents in place. You don't have a property power of attorney or any of these healthcare documents. And so then it leaves your family members in a very inconvenient place, and you don't want to do that to them. You don't want that for yourself. And so it really is planning to fail in that regard. And it's not that hard to get these documents. It's not that expensive. We talked about wills and trusts. and we will in a minute here and there, a little more expensive, and also extremely important, but these documents are not that expensive, and it's something that you can do today to help not only yourself in the future, but everybody you care about. So some of the benefits of planning early is really about choice and control. You get to choose how you'll pay for care, where you might receive that care. You can choose who will provide your care and when it needs to change. And all of these things, it just gives you as much control as possible over your own future and over what happens to you in circumstances when you might not be able to dictate that yourself. So just a quick recap, the 5 absolutely necessary estate planning documents for every single person over the age of 18 is a power of attorney, a property power of attorney, a healthcare power of attorney, a living will, and advance directives. Those kind of go together. You usually don't have one without the other. And a HIPAA authorization. Now, many people will also need a will and a trust. And I'll talk a little bit about those just so people have a little bit of information about what is a will, what is a trust, how are they different. I would argue that everyone needs either a will or a trust. It's terrible to go through probate intestate, meaning you have not documented your wishes at all. That's if you wouldn't have a will or a trust, but to just give you a little bit of information. Oh, before that, 1 in 4 20-year-olds will become disabled before they retire. And a current 65-year-old has a 70% chance of needing long-term care, 40% chance of entering a nursing home, and a 20% chance of being there at least 5 years. And Gail can attest to this. I mean, nursing homes cost anywhere between, what would you say, $8,000 and $10,000 a month right now.
I think they were costing it. It's like 10 or 12 to 13, kind of in this market. And then if you go further out in the
And that's
south
just
or country, it's a little bit lower.
right. And that's just for a single month. So if you think, okay, if a person is paying that every month for 5 years, we're talking about a really significant amount of money. And you can avoid paying that money through planning, an elder law planning, getting on Medicaid, getting VA benefits, maybe. But there are a lot of things that you can do so that you don't end up broke to get on Medicaid to pay for long-term care. There's also long-term care insurance. There are a few other ways to pay for a nursing home, but primarily Medicaid is the way to pay for long-term care. And it's another thing to think about as we talk about all of these documents is they're super important as you age, as you get older, as likelihood increases that you might need to use them. So now I'll talk about a little bit about the difference between a will and a trust. So a lot of times people have the misconception that a will avoids probate. Everybody has heard the P word. Probate is terrible. Probate is what will govern your estate if you do not have a will or a trust. But probate, you will also go through probate with a will. So will just governs the probate process. Without a will, you go through probate, they call it intestate, meaning without a will, and everything will pass through succession that is determined by statute. With a will, you have your wishes. The probate court will make sure that your wishes are honored, everything that you set up in that will. And wills are less expensive and complicated to create than a trust would be, but they are more expensive at death. Going through the probate process is not only super expensive, the fees are set by statute, so they can't be changed. It's also extremely time consuming. So probate can take 9 months, it can take a year and a half, it can take 2 years. And as your estate gets larger, the probate process tends to take longer. And so it's complicated, it's long, it's drawn out, it's inconvenient for your family members. So it's a few reasons maybe to lean toward the will or toward the trust versus the will. But for a lot of people, the will accomplish your goals. You know, you can dictate exactly who you want to leave your estate to. And for people who maybe have a smaller estate and have a lot of what we call non-probate assets, so assets that you can pass through beneficiary designations, and through payable on death or transfer on death designations, the will might be the way to go. A will is also, and I cannot emphasize this enough, absolutely necessary to name a guardian for minors or disabled children. If you have minor children, or if you have a child with a disability, you have to have a will to name a guardian for that child. And if you have any, it's hard for me to imagine a parent who would not want to have a say in who would take care of my child if something happens to me. And so that's why a will is extremely important. And with our trust plans, we also do what we call a pour over will, which pours your assets into the trust, but it's also a way to make those guardianship designations for your minor children. So just that's something to keep in mind. As far as a trust is concerned,
Can I say one thing about that, Amanda?
sure.
You were saying that, and I think what people don't realize either is on those insurance policies, they'll list their children as the beneficiaries. And if the children aren't 18, then the insurance company can't give them the money. And then if there's no people listed and what have you to act for them, they just hold the money until they're 18. And so that's not really too helpful. Someone that would have to go and become, petition to become a guardian and try to petition to have that. But then again, everything's being monitored and decided, how that money might be spent versus having somebody that really knows your wishes. And I don't think people realize they're leaving it to their kids, but if they're not at legal age to get it, it sits there. So.
Right. Right. Or you have to go through a conservator process, which is also extremely inconvenient, requires court supervision and annual accountings, if you're leaving assets to a minor child. So thank you, Gail. Great point to bring up. And then just a few things to note about a trust, how a trust is different from a will. I think a common misconception is people think of trusts as something that the extremely wealthy have. And it doesn't need to be. There's no reason for that. Anyone can own a trust, and everyone really has reasons that a trust might be the best vehicle for them to manage their estate. So a trust will pass outside of the probate process, meaning if you leave all your assets in trust, you will not have to go through probate at all, which could be very beneficial for your loved ones, your beneficiaries. It makes the process a whole lot faster, and a lot easier. A little trick with a trust is it will only govern assets that are titled to the trust. So if you think of a trust as a bucket, you have to put all of your assets in that bucket in order for the trust to control it. So if you have a bank account, you have to make it payable on death to the trust, or you have to put it actually into the trust name. That makes sure that the trust is actually controlling that asset. As far as a car, you'll put a TOD on the car title, so it'll go to the trust. Your house, you might do a beneficiary deed. That'll make sure the house ends up in the trust. So every single asset you have, firms like ours will look at and say, okay, this is how we'll handle it to make sure that it ends up in the trust. And then it will end up going to your beneficiaries in the way that you dictate in the trust agreement. Now, trusts do cost more in terms of both money and time to put together, but that's because you have a lot more control of exactly how you want your assets to pass through a trust. With a will, you can usually say, I want Susie to get this percentage of my estate, and I want John to get this percentage of my estate. Whereas with a trust, you have a lot more flexibility to say, okay, I want this much money to go to Susie, but Susie's not great with money. And so I'm going to tell her she can only take $5,000 a year for the rest of her life from the trust. Or if you have a child with a disability, you can set up a trust in such a way that that child with a disability will still get the benefit of your estate after you pass away, but that money is controlled by a separate person, by the trust. So it wouldn't get your child with disabilities kicked off of any benefits they might be on. And it won't just leave this massive pot of money to a person who might not be able to handle it. And trusts vary widely. Um, and attorneys, experts are really necessary to accomplish your goal. And that's a huge benefit of trusts since they're so unique, since they're so modifiable. You can really tell us what your primary concerns are. Are you concerned with avoiding taxes? Are you concerned with asset protection? Are you really concerned with, okay, I just turned 70. I'm, in not as good of health as I once was. I'm concerned that I will need long-term care in the somewhat near future. Well, we can use trusts to shelter a lot of your assets and get you applied for Medicaid and thinking about, Medicaid has a 5-year look back period, VA has a 3-year look back period. These are all things to consider in your individual circumstance. And so that's why you should talk to professionals. You should talk to people like our firm who do this kind of planning and help you talk to you about your goals and what exactly would most benefit you as you look to your life now. Yes, your life 5 years down the line, 10 years down the line. Maybe you're thinking about SSI. Maybe you're thinking about veterans benefits. Maybe you're thinking about Medicaid. Maybe you're not thinking about any of those things and you have a 2-year-old, a 5-year-old, and a 10-year-old right now. And so your trust will look much different from that 70-year-old I was talking about. But that is the beauty of trust, is it's a whole lot more flexible. So that's just a little overview of here's a will, what it does, here's a trust, what it does, how they operate, and why both of those documents are important as well. Any questions?
Oh, that was a big summary. That's really good.
I tend to talk a lot once I get going.
I just think there's just so many aspects that people don't think about. I know prior to, really working in elder law is something I didn't really think about stuff. Like, you don't think about that with the minor children, people just put that but there's just a lot of things to think about and there's a lot of resources. And just people kind of procrastinate a lot with it. And they think, oh, I'm not old enough. But yet, it really starts at an early age needing to have that because you just don't know when you're going to have an accident or when something's going to happen that you can't express your wishes. And I know it's kind of strange, and you might speak to this, like Missouri doesn't have like a surrogacy law. Like some states, your spouse can kind of speak for you. Some of the hospitals here, it just depends how it's going. They'll kind of defer to some of the family on a little bit, but they don't really have to, and they're not supposed to. And then you gave the example of the people that were near death and the spouse thought one thing and the parents thought another. And if you don't have any documents, sometimes they're doing what they can to keep the person alive, or they're kind of listening to the family even without. But if anybody's in disagreement, they don't have to listen to anybody, and they don't. So that's kind of hard.
Right, and their hands are tied. And you're exactly right too. Missouri does not have, some states have statutorily set healthcare powers of attorney, people who can make decisions for you if you're unable to make them for yourself. But like Gail said, Missouri does not. So do not think, oh, if something happens to me, it's fine because my husband will decide. It's not the case here. A lot of times healthcare providers, like Gail said, do listen to family members and what they say, but they're not legally required to. And if they feel like there's any liability that might come down on them, they probably won't. And that's why, when you get family disagreements like that, healthcare providers do not want, nor should they have to, make any kind of decision like that. And that's why having documents like these in place ensures that the hospital will do what you want them to do, and it just makes it easier for your family. So they're not put in that position of, well, she said this to me one time, so it means she must want to be kept alive. Or she said this to me, and I don't think she would want, an artificial machine beating her heart for her, that kind of a thing.
Yeah, and I don't know if you've been in the experience yet, Amanda, but I've been in it 2 or 3 times now where, we had to decide to, like pull the plug, not do any other things. And it's really difficult. And, and if you're a parent and you're expecting your kids to do that, kids don't want to see their parents suffer, but you don't necessarily, or even your spouse, you don't necessarily want to see them go either. And it's a heavy responsibility, because then all of a sudden, if you didn't know what your parents' wishes were, and per se, you're doing it because that's what maybe you would do, or you think it's right, then later you're feeling maybe guilty because you had to do that, because you don't want your parents to leave, or your kids to leave, or your spouse to leave. But if you know that's really what they wanted, I think later it kind of gives you peace that you made that decision, because you know that they were suffering and that's what they wanted. And so you're not feeling like you did something to
Right.
them. It's
Right.
kind of what.
Not only having the legal documents in place, but also having those tough conversations with your
Mhm.
family members.
Yeah.
It makes it a whole lot easier for them if you've already told them this is what I want and this is what I don't want. Because then at least they have the comfort of this is what mom wanted. This is what she
Mhm.
told me.
Right. Right. And, we talked about that surrogacy, that there's no surrogacy here in Missouri, but, a couple other things really is, that, um, that no one can like really petition to be a guardian without an attorney. Like, I'm originally from Michigan, and I had found out, in Michigan, family members, they can fill out some papers and submit them to the court themselves, or people can do that. And even some of the nursing homes there can do that. And, but well, anybody could do it, and you don't need an attorney necessarily. But here you have to have an attorney.
Right.
And so that's interesting. And then also for probate, you can't admit things in probate without an attorney here in Missouri. Where I just recently found out in Michigan, you can do that too. So all the states are different.
Yeah. Yeah. States are very different. And that's why it's important too to know your state and their rules and do your best to plan for realities that will occur where you're currently living. And if you do move, a lot of older people, they move to maybe Florida or Arizona, a place like that. It's also important to keep in mind, I should probably update these documents. Because a property power of attorney that's executed in Missouri and valid under Missouri law might not be effective in whatever state you move to. So it's a good thing to keep in mind if you have a plan like that, if you have moved from somewhere else, making sure you update documents like that because you want them to work in whatever state you are currently living in.
And what do you, I think, and you can speak to this, the like people that are like, say, snowbirds, and so they know they're going to, like, we're doing their documents here, you're doing documents here in Missouri, but you know that they're going to Florida for 4 and 5 months every year. There's sometimes, isn't it, that you look at kind of the state laws there too, that some things might have to be in there that aren't here, and you kind of design the
Right.
documents so they work in both places?
So you can, and especially with healthcare documents, I think it's a good idea to get them for both states. But also, if you're technically still domiciled in Missouri, so if you spend more than 6 months of the year in Missouri, if you're considered a resident of the state of Missouri, then your documents should still work, even if you're a month in New Mexico or 4 months in Arizona every year. Those documents should still be effective for you. Only because they would apply Missouri law since you're a visitor, not a resident of that state. But I don't think it's a bad idea, especially for healthcare, to have documents from that state in case something does happen when you're a few months in Arizona every winter and you get in a car accident, something like that, just in case, and you can leave them at your house in Arizona or leave them in your house in Florida, just to be safe.
So I guess I was thinking, I know, in some states, certain things have to be notarized and in other states they don't. And in some states, things have to be witnessed and some states they don't. So sometimes, like, I don't know, and I don't know which ones are which or anything, but say we didn't have to have a witness on something here, but in Florida they did, and they were going that much, we might do a document here that has the witness just so it would work here or there, or the notary or something, just so it would work kind of both places, not necessarily having two, but just to that higher standard. Or I know another thing I learned in Michigan, being from there with my dad, that the power of attorney, like especially for healthcare, that the person that was going to be the agent had to sign accepting it. And that's not something that has to happen here by any means. And I guess I would just encourage, and you can speak to this too, is like encourage people. I think a lot of people get the documents and then they don't tell the people that and then all of a sudden something's happening and you're like, okay, well, you're the power of attorney. And they're like, what? I didn't know that. So I think that's like in that state, that's why people have to sign accepting that responsibility. So it's kind of interesting because some people aren't really ready or wanting to have that responsibility. And then by then, no one else can be appointed. And so that's kind of something to make sure you're talking, like you said, the hard conversations. So we do have a question in the chat. You might look at it. It says, what about verbal confirmation? Like if a person cannot sign for whatever reason, but they have capacity to name someone.
Like what happens in that?
Yeah, how do they go about doing that?
Well, let me look at it. Well, that can be okay. That really just depends. Um, like it's hard to tell if a person is legally competent to make decisions if they're not able to voice things. Um, you're saying though they can verbally consent, they can't sign. So maybe something like a Parkinson's, is that what we're talking about? Um,
Maybe you can write an example in the chat. But I think that too, people, a lot of times people can't sign, but you can make a mark.
right.
And usually your notary block.
And it was a woman who had MS, and she was able to make a mark, even though she couldn't sign her full name. But we did powers of attorney for her and all of that. Even though she was still able to authorize the documents without being able to sign her full name. But it's another reason that those documents are helpful to have.
Yeah, and it's important when they're doing that, like the notary block is kind of different as well.
Right. Okay. Gail, I'll let you answer that. I have never seen a verbal without parking.
Yeah, I'm not sure either. I think this question is kind of coming from the hospital. I think they do have a procedure of how they do it there, but maybe we'll have to follow up a little bit more about it. But yeah, and again, I think that's something why it's important to consult an attorney. And I mean, it just hasn't run into this situation yet, but it's probably going to be the first thing you go and look up after
It
this.
definitely will be. Well, and I would think if which is
Yeah.
hard.
Yeah.
It-
So
it's like-
that's where, so the question being in there for people that know is like the family members maybe are disagreeing and that person does have capacity, but they're not able to, you know, sign and stuff. So honoring that person's, trying to honor that person's wishes and trying to navigate with those different family members. And that is, that is a big, that is a big thing. That's a big part, where, you know, social work or the chaplain or any of those types of things comes into this, because there is a lot of skill about negotiating with those different family members. And, you know, certain family members, a lot of times they don't like each other or they're having problems, or it brings out a lot of our stuff from childhood problems. You know, it's like 40 years ago, but you got that debate. And it's really, it is a hard thing to navigate. And the, you know, the attorney, or you're trying to look at it, you know, legally and what has to happen, but working through all those emotions, of the situation can be real difficult, which you're just now seeing as being here. And
Oh, yeah.
uh,
And it sounds like, I mean, ideal circumstance is this individual would have made those decisions and had the documents in place before something happened when he could have signed. And a benefit to that too is you name one person and it helps healthcare professionals because then they can say, well, this is who she named, good, bad, or otherwise, you know. It sort of helps you diffuse some of that family tension, which is still there because obviously the person who wasn't named might want to make the decision. Um, but it does at least give you a little more credibility to, you know, this is a person that they wanted, this is the person that is legally able to make the decisions.
yeah.
So yeah, I'll make sure to look that up, but sounds like a very uncomfortable circumstance. I would say.
Yeah. And again, it's why we should, really be looking at it ahead of time. And I think that people, again, it's that you're young and you just don't think that you need it, but you really need the documents more, I think, because it's, if you're disabled more so, you know, if you die in the accident, then yeah, people are worried about, you know, probate, you know, maybe that makes it longer or harder. But it's, if you're in the hospital and all these things are happening, and that and then they have to pay your bills and everything because you're still alive, and it's just going on for a really long time. So that kind of can be just a really hard situation. Yeah. Well, thank you so much, for doing this for us today. And I'm sure that anybody listening, it's going to be really helpful for them. And you know, this is the caregiver series, and when you're trying to caregive for someone, these things are real important. It's kind of giving you those clues of what you need to do, and then what we all need to do for ourselves too. And so keep watching and everything, everybody, for our next in our series of caregiver talks. And we will, you know, keep presenting them all the time. You can find them here on our page, on Aging Advantage, or we also have a YouTube channel and they're saved there, and so you can go directly and watch them. Thank Thanks again, everybody, and we really appreciate you being here today.
Thanks so much for having me.
Thanks.